my name is Robert Walker, and this is the 8th in my series on managing insolvency in troubled times. I've subtitled this instalment, Compromise the Inception, because I'm now going to describe the basic law on this, the matter of compromise. I'm only going to deal with part 14 of the Companies Act. There is another part of the Companies Act that deals with compromise, which is part 15, but to invoke part 15 you need to go to a court. I won't deal with that. The start point, aside from the definition section, which is section 227, is section 228. Now, I won't read it out, but you can see it has several parts. It refers to those persons who are entitled to invoke a compromise. It refers to a belief that the company is basically on the cusp of insolvency, and we'll deal with that later in this session. It identifies a set of people who are entitled to invoke a compromise: the board of directors, receivers and liquidators. I won't go and traverse that area again because we've already dealt with their role in compromise. And finally, subject to the approval of the court, shareholders and creditors can do that. Now, section 228 continues, and I have not quoted that, by saying that creditors or shareholders who invoke compromise through a court will be entitled to have as much information as they need. The possibility of creditors carrying out, or shareholders carrying out a compromise is so remote I won't even consider it further. It's possible, but... Now, within that section there are therefore 4 separate things that need to be considered. There's the proposal itself, there is the board, there is the nature of a compromise, and the definition of insolvency. Right. I won't go beyond the notion of the proposal. The proposal is proposed by a proponent, and those potential class of people are set out in section 228. I won't go beyond that. Right. As I'm focusing primarily on the board, we then need to think about what does the board need to do to begin the compromise. Well, firstly, if it's a sole director, that person is the board. If there is 2 or more directors, then you would need to have the matter attended by a lot more formality. You'd have to call a meeting of the directors, you would have to make sure there's a quorum there, you would make sure that there was a resolution to the effect that a proposal for compromise should be initiated, that 1 or more of the directors would be delegated with the authority to carry out the compromise on behalf of the board, and of course you would record that both as a resolution and then as a minute with the votes in favour or against. Very important to attend to those formalities. Of course, if you're a sole director, you would be well advised to go through the same procedure and have a resolution and a record to be put into the minutes of the company, which by the way are required by section 189. Now then, we'll now think about what is a compromise. Now, this is set out in the definition section, and I have quoted part of it. The definition section is 227 of the Companies Act, and I will read this one. Compromise means a compromise between a company and its creditors, including a compromise cancelling all or part of a debt of the company, or varying the rights of its creditors or the terms of a debt, or relating to an alteration of the company's constitution that affects the likelihood of the company being able to pay a debt. Now, I won't worry too much about that last long-winded phrase. The 2 things that I would like to emphasise is the cancelling all or part of a debt, remember the rescheduling of debts that I talked about before, or varying the rights of a creditor. In other words, maximum flexibility is conferred upon the process of compromise. As we have discussed before, Justice Winkelman has reaffirmed the maximum flexibility in the Bank of Tokyo and Solid Energy case, which I've referred to before, but I will just emphasise the matter by ensuring that everybody understands that it's what the directors and the creditors agree happens, and nothing interferes with that. And she said in the judgment, therefore, I am satisfied that a compromise which is more complex than a simple acceptance of a lesser amount of money by a creditor in full satisfaction of the debt can be effected under Part 14, including a compromise that involves an exchange of debt for redeemable preference shares. Now, don't read too much into the fact that she specified a type of share. There's only one reason for that, and that was because Solid Energy was a state-owned enterprise and only the shareholding ministers could hold the shares. So it had to be redeemable preference shares, a slightly superior class of shares in terms of distributions, but shares nonetheless. Right, now that deals with the nature of compromise, maximum flexibility. Now then, let's just go back to the preamble in section 228, and it talks about the reason that a person who's going to be the proponent has reason to believe that a company is or will be unable to pass debts within the meaning of section 287. Now, that appears to be a restriction, because if you go and look at section 287, it identifies 4 separate events, for example, failure to comply with a statutory demand, a judgment debt, or indeed, the last one is that a compromise has been entered into. Now, does that mean if one of the events in section 287 hasn't been triggered, that then a person cannot invoke, or a director cannot, or the board of directors cannot invoke a compromise? No, that's not the answer, and that is for a variety of reasons. Firstly, I would identify that it would be an utter paradox if you had to have a compromise fail, which is the expression in section 287, before you could invoke a compromise. That would be a complete circularity, paradoxical, and wouldn't happen, basically. But perhaps more important than that is that the test is a subjective test. What it means is that a person has a belief about the future. It's not, has it actually happened, and that is objectively determined. This person believes that at some point, for example, a statutory demand will be issued and the company will not be able to satisfy it. Thirdly, I'd also note that if you read section 287, it says that section 287 is subject to section 288. Now I go back to the Bank of Tokyo again, and there was an argument that the compromise put by the Bank of Tokyo itself, that the basis upon which the compromise was invoked was invalid because the directors had relied upon a balance sheet version of insolvency, and therefore it didn't satisfy this apparently extremely stringent and almost impossible to meet test set out in section 287. Well, again, we have Justice Winkelmann to thank for clarifying this and adopting a common sense answer. And she says this, in respect to this argument about a balance sheet insolvency test. I accept Solid Energy and the interested parties' argument that the distinction Bank of Tokyo seeks to draw between balance sheet liquidity and cash flow liquidity is an artificial and uncommercial distinction. Good. When cash flow issues are addressed, this will usually assist the balance sheet, and the reverse is also true. In other words, she's saying they are two sides of the same coin. So let's not get too fussy about the meaning of insolvency and the belief in the mind of the directors in this case that such an event is imminent. As you can see, that everything that Justice Winkelmann has done, and that I fully support, is to make that which has been prescribed in legislation for the specific purpose of facilitating solvency management or insolvency management with the minimum fuss, as was the original Law Commission wished, as Justice Winkleman spelled out, is to make it simple and flexible. I would say with respect to solvency that given the notion of confirmation bias, if a director thinks that the company's insolvent, it almost certainly is, right? Most directors have the opposite inclination, hence the confirmation bias. They, like Mr. McCormick, think something will turn up. In any event, I would say, and I say this again and again, if the directors and one of their number acting as a proponent act with complete candour and with honesty, and they are clearly doing so in the interest of the creditors, I don't think anything can go wrong. Please, if you wish for written material, look below the video and you will find ways to acquire it. Thank you very much. Bye.